update, to also give our thanks to all of our fantastic supporters. In particular, we wanted to mention our advisory committee. A great, fantastic group of people have come together to support this first-time event. We've have a wonderful group of sponsors and law firms and other organizations that have really stepped up to support what is is really quite the diverse and multinational event. It really, we think, and part of the intent of putting this event together is to truly reflect the highly diverse nature of international arbitration and how it has grown fantastically over the last 15 to 20 years, to reflect the kind of diverse topics and the different types of legal cultures and practices that we see in the practice of international arbitration. And I'll just pass over to Jose Antonio now, but I wanted to in particular mention Jose Antonio, Maria Lucia Casa, and the whole X Strategy team for their incredible efforts in putting this event together. The logistics involved and herding all the cats has been amazing, and I just wanted to mention Jose Antonio and his team. They've done a fantastic job. So Jose Antonio.
Thank you, Ian, for those kind words. I don't want to steal too much of your time. I would simply ask one question, given that there is, of course, a proliferation of events and Zoom events, including international arbitration. That being said, however, together with Ian, we felt that there was and there is a need for a world arbitration update, for two reasons, which are the focus of the World Arbitration Update. One is trying to decentralize international arbitration, and that means that it is obvious by seeing the caliber of panelists in this session that international arbitration goes beyond London and Paris and New York, even though we love New York. Charlene is here. And we love London and Paris as well, but we have attorneys and counsel who are rigorous and incredible in Ukraine, in Japan, in Panama, in Singapore, etc., in many places of Africa. And we wanted to make sure that the world knows this, and that there is international arbitration being practiced in non-traditional venues. That is the first objective of WOW, or World Arbitration Update. And the second objective, which was mentioned by Ian, it is updating international arbitration. Say 20 years ago, when well, not that much, but almost like about 12 or 13 or 15 years ago, when I worked at Ghcl, you could still read most of the awards in a year. With a little bit of discipline. Now it's simply impossible to read 140 awards that come in a year, and the same thing for international commercial arbitration. So the other objective of World Arbitration Update is to provide a number of topics to the public meaning from students to very sophisticated practitioners, an update in a media that is useful, because you can watch it, you can scroll through it, etc., and that would be there for the public. So those are the objectives. I want to underscore the support of our sponsors, including Ghcl, Real, Washington Arbitration Week, and many others of our circle of firms, many of whom are here, and of other damages firms, as well as other organizations. And with that, we would like to welcome everyone to WOW. Now, please, Gene, take it away.
Thank you very much. Thank you, Ian. Thank you, Jose Antonio, once again. Appreciate your organizing this event, and thanks to the sponsors who made this event possible. Going back to our panel, The structure, because we have two questions, there are two issues to discuss. The structure will be a little different from a conventional panel. First of all, the difference is that we will have a presenter, Charlene, and I'll make a more detailed introduction of who Charlene is. We'll have a presenter who will discuss the general issues that are applicable to all jurisdictions that are involved, that are represented in this panel, after which we will give word to the panelists who will address issues that are specific to their specific jurisdictions. After which we'll go back to Charlene, who will again introduce the second issue for the discussion, and then we'll go back again to the panelists. After these two rounds of discussions, we will do a very brief 10-15 minutes, hopefully, a Q&A session, during which the questions that you, the participants, will send us by way of Zoom will be asked. I'll moderate the Q&A. I'll ask these questions of the participants, of the speakers and of the panelists. And after that, there will be a 15-minute breakout session, a networking session. All the participants will be distributed among breakout rooms, and you will have opportunity to have a free-flowing discussion with members of the panel. So without further ado, I'd like to introduce our speakers. And the presenter, of course, Charlene Sun. Charlene is a partner with DLA Piper's International Arbitration Practice and represents clients in international arbitration and multi-jurisdictional cross-border litigation disputes. Her practice focuses on enforcing foreign arbitral awards and judgments against sovereign and non-sovereign debtors and asset recovery. She is fluent in matters involving foreign sovereign immunity and other complex jurisdictional issues that arise when litigating foreign disputes in U.S. courts. Charlene also represents clients in contracts and treaty-based arbitrations involving complex commercial disputes arising out of Latin America, Europe, and Asia. Thank you, Charlene, for joining us. And our panelists, we have 4 panelists today from Japan, from Ukraine, from Panama, from Singapore. And our panelist from Japan is Yoka Maeda. Hi, good evening, Yoka. Yoka is a partner in the dispute litigation and arbitration practice and CTU partners in Tokyo, Japan. She focuses her practice on complex and cross-border disputes across a wide spectrum of matters, including commercial, construction, life science, pharmaceuticals, technology, and investment in domestic courts and international arbitrations under major institutional rules. Yoka regularly sits as an arbitrator as well as the counsel. She is qualified in both Japan and New York. She is a court member of the ICC Court of Arbitration since 2018. And our next panelist is David Mizrahi. Hey, David. David is a partner in MDU Legal in Panama. David focuses on multi-jurisdictional issues, including transactional and dispute resolution work. He represents major conglomerates and large multinationals doing business in Panama on a wide range of legal issues. David has substantial experience in both common law and civil law jurisdictions. He served as an arbitrator and counsel in commercial and sovereign arbitrations in major international institutions. He also served as expert on Panamanian law in court cases in the United States and Israel, Canada, Jersey, England, BVI, and Panama. Our panelist from Ukraine is Tatiana Slipachuk. Welcome, Tatiana. Tatiana is a special advisor to the law firm Sayenko Harenka in Kiev, Ukraine. Tatiana has recently returned to private practice after serving 2 years as the chair of the Central Election Commission of Ukraine. Prior to the government service, Tatiana had an active arbitration practice where she practiced for decades, both as counsel and arbitrator. As counsel, she represented clients in nearly 80 arbitrations, including both commercial and investment cases. As an arbitrator, she served in nearly 400 cases. Is it correct? Is it 400 cases? Yeah.
Yes.
She nods her head. Yes. Wow. In major arbitration centers. Tatiana also served as an expert on Ukrainian law in arbitrations and court proceedings, including the High Court of Justice in London and the BVI High Court. Tatiana authored over 150 articles and chapters and books on international legal issues. It's very impressive, incredible achievements. Thank you, Tatiana, for joining us. And last but certainly not least is our panelist from Singapore, Lip San Ho, who is the head of the construction and project practice and partner in the international arbitration practice in one of the largest Singaporean firm, Raja and Tan, lawyer for construction by Chambers Asia Pacific since 2015. He was also recognized by the Legal 500 Asia Pacific and best lawyers and in the international who's who of construction lawyers. He focuses his practice on construction disputes, on engineering disputes, as well as advising clients in various project-related issues. With over 25 years of experience, he practiced. He was representing clients in both Singapore and various arbitration tribunals across the Southeast Asia region. Lip San is a fellow of the Singapore Institute of the Arbitrators and an accredited adjudicators. Without further ado, I'd like to give word to Charlene, who will introduce the first topic. Thank you, Charlene.
Thank you, Gene, for those very nice introductions, and thank you everyone for joining us today. We start our discussion with one of the most commonly invoked grounds for non-recognition under the New York Convention, the public policy exception. It is found in Article 5.2b of the Convention and permits national courts to refuse to recognize a foreign arbitral award if recognition would be contrary to the public policy of the country in which recognition is sought. The Convention does not itself define public policy, which has left it largely up to national courts to define the contours of the exception under their own domestic laws. There has been a lot of discussion of the public policy exception by commentators and courts, and most of it really focuses on its potential for over-application. Although public policy can be an amorphous concept, the travaux préparatoires of the Convention demonstrates that the exception was not intended to be a catch-all for any violation of domestic law, but rather should function as a safety valve to allow national courts to deny recognition to arbitral awards that would truly offend the fundamental values of the foreign state. Contracting states generally agreed that while the safety valve was necessary to include in the Convention, it should really only be pulled in rare and extraordinary circumstances, lest the exception be allowed to swallow the rule of enforcing arbitral awards. And the underlying purpose of the Convention to create a uniform enforcement framework to prevent foreign awards from being unduly discriminated against. And surveys of case law have demonstrated that most national courts in convention states have heeded the drafters' intentions to treat this exception as exceptional. But the question remains, what kinds of values, and principles rise to the level of being considered part of the forum state's public policy? In the United States, for example, the federal courts of appeals have defined public policy as the forum state's most basic notions of morality and justice, and have required that such policy be explicit, well-defined, and dominant. Now, examples of successful Article 5.2b challenges are really few and far between in the US, but one area where the US courts still appear to be puzzling through what role the public policy exception should play is in cases where international relations are implicated by the enforcement of a foreign arbitral award. For example, in a 2018 decision from the District Court of the District of Columbia called Hardy Exploration versus India, the court applied the public policy exception to decline recognition of an arbitral award, which required the government of India to permit a foreign oil and gas investor to continue its exploration of an offshore concession in India. The US court did so on the basis that confirming an award requiring such specific performance of the Indian government would encroach upon India's control over its own territorial integrity and thereby violate international comity, which the court considered to be part of US public policy. Now, the Hardy decision has been criticized by commentators as precedent that may have opened the door to expanding the public policy exception with respect to investment awards, every one of which could probably be characterized by the foreign state debtor as an affront to its sovereignty. And for what it's worth, I think this is a case where the court had valid concerns about its ability to actually enforce the relief that was granted in the award, and perhaps use the public policy exception as a way to express those concerns, but in doing so may have unduly elevated the concept of international comity, which is a concept almost as amorphous and difficult to define as the concept of public policy, to the status of an explicit and well-defined underpinning of the US legal order. In any event, the Hardy decision illustrates how complicated questions arise when national courts consider what role domestic public policy should play in matters affecting international parties and international relations. Should national courts take a more international perspective in applying the public policy exception? For example, should the offended domestic policy also be enshrined within international public policy to justify refusal of recognition under Article 5.2b? And what if refusing enforcement on the basis of a domestic public policy would actually violate an international public policy? Today, our distinguished panelists will tackle some of these issues and discuss the contours of how the public policy exception is applied in their respective jurisdictions and how considerations of sovereignty are balanced against each contracting state's treaty obligations under the convention. Gene, I think
There we go. Yeah. Thank you, Charlene. Thank you very much. First, we will start our jurisdictional discussion with Yoka. Yoka, please go ahead. Don't forget to unmute yourself. There we go.
Yes, thank you very much, Gene. Hi, everyone. Because I'm a speaker, I'm a panelist from Japan, I'd like to talk about several court cases related to enforcement. But actually, so far, there has been no court precedent in Japan that is related to enforcement or refusal of enforcement of arbitral award based on public policy. So what I'd like to discuss, or what I'd like to introduce this evening is the court precedents in relation to the enforcement or refusal of enforcement of foreign judgment based on public policy grounds. Although there are differences between judgment and arbitration award, I think those court cases could be a good kind of could give some thought on what would happen in case of enforcement of arbitral award. And the first court case that I'd like to introduce is a Supreme Court case which refused enforcement of the arbitral award based on the public policy. And the court said it is against public policy of Japan to enforce the foreign court judgment which allowed the punitive damages. Because the Japanese civil procedure law, no punitive damages are allowed and only compensatory damages are allowed. So the court only allowed the enforcement of the punitive damages part, the compensatory damages part, but the court refused the enforcement of punitive damages part. So I think this could be a kind of common topic in various jurisdictions, because I understand in many countries, punitive damages are not available. So if punitive damages are awarded in the arbitral tribunal, and when the winning party try to enforce that award, this could be a kind of common issue in various jurisdictions. And one thing that may be interesting is, and related, is whether, let me start over. In addition to not allowing punitive damages, in Japan, there is a limitation of possible interest that can be demanded. So, for example, for the amount more than 1 million Japanese yen, which I believe is 10,000 US dollar, the maximum allowed interest is 15%. So there could be another issue whether any award which allows interest more than 15% could be enforced, for example, in Japan. And a related topic is whether, if the court finds, the award which allows the interest more than 50% is entirely should be entirely refused to enforce, or should be just partially refused to enforce. And based on the Supreme Court case that I just introduced, I think the likely outcome is that only the portion that is above the maximum interest be refused to enforce. So that is my observation. There has been no court cases so far. And I think my time is limited, so I'd like to quickly move on to the next topic. And this is court case related to cost of litigation. And to be simplified, this is a case where the winning party won the case in Hong Kong court, and the court ordered the winning, the losing party to pay the cost of lawyers of the winning party as well. And because in Japan, the cost of the litigation is the cost of the counsel be paid by each party. So it became an issue whether such judgment which orders the losing party to pay the lawyer's cost of the winning party can be enforced. And the result was the court allowed enforcement of such foreign judgment. So this is also kind of related topic, because in arbitration, as as many of you should know, that it is quite common that the tribunal orders the losing party to pay the arbitration cost of the winning party, including the cost of counsel.
Thank you, Yoka. Thank you very much. It was a very interesting, and I'm sure there will be questions about your view from Japan. Now we will travel through our hyperspace vehicle across the world to Panama and ask David Mizrahi to give us Panamanian perspective on a public policy exception, how it works in the courts of Panama.
Thank you, Gene, for allowing me to open this Pandora's box. And indeed, it's a very interesting topic. I also want to thank Jose Antonio and Ian for organizing this World Arbitration Update and for inviting us to speak. Panama has had the benefit of a relatively new and modern arbitration law, which incorporated the principle of rejecting enforcement based on pretty much the same concepts or the same exceptions that are outlined by the New York Convention. So in that sense, our domestic arbitration law mimics or copies this concept of public policy. However, as Charlene so ably said it earlier, it doesn't really define it. So it's left very open-ended. And the way that circle has been closed is by the enactment in a few years later, 2 years later, of Law 61, which is Panama's Code of Private International Law. So Law 61 actually has a definition of public policy, rather public order, which is the concept many civil law jurisdictions use to roughly translate this concept of public policy. And I would like to ad-lib the definition, which is set out by the, and curiously is not set out in the arbitration law, but in the Code of International Private Law. And I'd like to read it out loud because it says, international public order is the reserve or power of the judge to be able to reject, by virtue of this exception, the applicability of a law, of a foreign law or foreign treaty, which application within a determined cause shall have the judge violate principles or norms which are fundamental to its positive order, or to its positive, or to its substantive policy. That's how I translate. Then it goes on to define what Panamanian public order is, and it's a much broader definition. And it says it is the collection of imperative norms of Panamanian legislation that the parties cannot ignore. So that is basically what it is giving us by way of defining what international public policy is. So I can note, for example, the words fundamental as it relates directly to the international public policy. But when it talks about Panama, Panamanian public order, it's much broader. It says normas de obligatorio cumplimiento, which means obligatory law. Now, what's obligatory norms? That's another open question, because each court is going to say, well, this is a norm that must be applied. Another court may say, no, it's a norm that the parties have the option of attending or ignoring. Now, it also has, and this is even more curious, on Article 7 of the Code of International Private Law, it says, the legal effects of an action or foreign law shall not be recognized neither totally nor partially when its application violates the international public order. Then it says, foreign law shall not be applied, foreign law shall be, in those cases, I add, supplemented or should be trumped by the internal law. So that's what the codes or the laws are giving us, the black letter law per se. When we look specifically at how the enforcement exception based on public policy is outlined in the arbitration law, it says that the recognition or the enforcement of the award shall be contrary to the public international order of Panama. So there is the interplay between the two definitions that I read earlier. Looking at how the courts applied in Panama, there's a court that has basically exclusive jurisdiction on determining this. It's not a court, it's a chamber of the Supreme Court. It's a fourth chamber of the Supreme Court, which is the one that looks at or decides enforcement matters of foreign arbitral awards and also the exequatur. That court has issued basically 2 rulings since 2015. One of them tried to expand on the definition based on foreign doctrine. And it says, by this definition, we can conclude that the public order is breached when an action is executed which is contrary to the fundamental principles of the state's general interest, principles which are found in the Constitution, the laws, and the regulations of our internal laws. And basically, in that case, it said that there was no violation of public policy or of public order. That case is dated 2016, March of 2016. There's another case in which they went even further and they defined public order as fundamental principles tending to justice and morality that a state wants to protect, rules that are oriented to sustain the essential interests of the states in political, social, or economic matters, known as loi de police or rules of public order, and the general respect of, and this goes to the issue of comity, which was alluded to by Charlene as well, to respect obligations contracted between states and international organizations. Finally, this concept is also latent in the set-aside provisions of domestic arbitrations. So in that sense, in that context, it has been examined quite a bit by the Supreme Court of Panama, by the 4th Chamber. Thank you very much. I think I'm out of time.
Thank you, David. Appreciate your view from Panama. Our next speaker is Tatiana from Ukraine. So we'll be traveling to Europe. Right now. Tatiana, it's your turn.
Yeah, thank you. First of all, I would like to join the words of deep gratitude to the organizers and say that we are honored to be at the beginning of such great event and among so distinguished panelists. If to speak about Ukraine, maybe I will just concentrate on the issue which appeared in our life suddenly with great pity. It's the events of 2014, the aggression of Russian Federation, and definitely this situation could not but influence the notion of national security, which became of paramount importance for the Ukraine at that period of time. And in this regard, the notion of national security, in a certain extent, influenced the understanding of the public policy in Ukraine, including with regard to the enforcement of foreign awards. In 2014, the specific law on sanctions was adopted in Ukraine, and this law, as in many other countries connecting with the sanction regime, has introduced some sort of prohibiting actions like such the prohibition of transfer of assets, fulfillment of the economic activities, financial obligations, etc. And on the other hand, it tied this to the notion of the national security and the adherence of the company to the country aggressor. And in 2015, the Ukrainian parliament adopted a specific decree where the Russian Federation was announced the country aggressor. Also, it was a period of the prohibition of export activities, etc. And definitely in private sector, it caused the violation of the contracts. And Ukraine faced first the execution of 2 awards issued by the Russian Federation ICA, the International Commercial Arbitration Court attached to the Russian Federation Chamber. And this specific issue was that there were 2 awards, and the first one, after 2 circles of the court proceedings, actually finished by the decision of the Supreme Court, which said that the sanctions are not the part of the Ukrainian public policy, that actually the sanction regime is something which lays in another field it could be referred to only in respect of the further execution of the award, and if the country or if the entity is in the sanction list, so the execution could be stayed by the authorities which are obliged to provide for this execution. But in almost a couple of weeks, this position has been detrimentally changed, and the second award between the same parties issued by the International Commercial Arbitration Court attached to the Russian Federation Chamber of Commerce and Industry. Again, after the circles of going from first instance to the third, finished by quite opposite decision of the Supreme Court, which said that sanctions represent one of the new aspects of public policy in Ukraine. And even the relations between these two cases were referred as that in the first one, the court did not examine all the obstacles and all the circumstances of the case, and finally they did not pay attention that the claimant is in a sanction list. It is connected with the military industry of Russian Federation, and it means that if the award would be executed in its favor, potentially it can be advantageous for the Russian military industry and disadvantageous for the Ukrainian national security. Because of this reasoning, the court said that not the execution authority, but the court itself is responsible for final decision, and that means that this award could not be enforced and could not be executed. But at the same time, the court mentioned that if in a certain extent or for any events, this company would be dropped from the sanction list, it will give the claimant the possibility to restart the execution. Needless to say that at the same time, the court did not manage to refer what would be the procedural grounds for that, taking into account res judicata issues, the terms for the applying for execution, etc. And finally, the third award, which was issued very recently, made very serious conclusion from the point of the enforcement. It was said in this award, which was issued by the Supreme Court against the enforcement of the Stockholm Chamber of Commerce award issued in favor of Ghcl against the Ukrainian state entity, with the reference that on the one hand, the Ukrainian state entity is one of the objects for the big privatization, and the execution of such award would be detrimental to the Ukrainian economic stability and to the budgeting. And on the other hand, the Ukrainian court paid the attention that among the creditors of the claimant is the Russian bank, Gazprom Bank, which is also included in the list. And that this can mean that the money received by the claimant can be used by the Russian bank as well, probably for the needs of the Russian military industry. The latter also was connected with the issue of the national security, that such type of the payments are in very rigid violation of the national security notion. This is very important decisions because any party now should consider if there is any relations in further execution with the Russian Federation, Russian entities, they can face as a problem. Hope I'm in time.
Thank you, Tatiana. I appreciate it. It was a very interesting view from Ukraine. And the last view is from Singapore. Just going back to the east. Now, Lipsan, please.
Thank you, Gene. Thank you to everyone, the organizers and the attendees for listening in this evening, morning, wherever you are. I saw a very friendly hello from someone from Haiti a moment ago. In this new normal where everyone is struggling to maintain commerce and active practice, resolution of disputes in an efficient manner, I think a forum like WOW is very, very key. And I would just like to bring us back to the topic at hand, which is a comparison between the civil and common law jurisdictions. So for Singapore, we are a common law jurisdiction. Therefore, whatever influences international arbitration practice on our tiny little island state comes from the laws that are made by Parliament, as well as judge-made law in terms of judgments of our courts and judicial system. Now, Charlene has done a great job introducing this topic, and everyone should take note that Article 5 of the New York Convention essentially has the two most common limbs where a disgruntled party attempts to challenge an arbitration award. The first being that the matter or the dispute was not capable of settlement by arbitration. And the second, which concerns this panel today, is that the recognition and enforcement would be contrary to the public policy of that country. Now, as users of arbitration, as counsels, as arbitrators, I would hazard a guess that for many, forum shopping might be an issue that would influence the approach to the underlying arbitration clause right at the very beginning. But as dispute resolution lawyers, we are served whatever comes to us at the end of that process. Now, if you have an arbitration clause that points towards Singapore or an enforcement that involves Singapore, you should take heart in the fact that Singapore jurisdiction is generally viewed to be one of the most pro-arbitration regimes in Asia, whether it's the ICC where Yoko hails from, or the SIEC or other jurisdiction institutions, that there are plenty of good established IA international arbitration practices in Singapore. Now, the courts have therefore had opportunity to consider the public policy objections, and it's gone up as high as our Court of Appeal. The judgment involves this Indonesian entity called Persero against a bank called Ghcl Bank. And very importantly, the court observes that enforcement challenges would only take place when it is an exceptional case and when upholding of the award would shock the conscience and clearly injurious to the public good. Very, very strong language. They go on to say that it has to be wholly offensive to the ordinary and reasonable person. And as David points out, under Panama law, you have notions of morality and justice introduced as well. So my observation would be, whether you listen to the Panamanian voice or the Japanese voice, I think you're starting to see very common threads that would deal with public policy. And in the Persero case, the application was dismissed because the courts felt that the second award, which was published without even an oral hearing, was merely a rehash, a ventilation of the same substantive issues in the first arbitration. And that was not something that they would stand for. And there is another case I would just quickly deal with before I hand the mic back to Jean. This is a 2015 decision which involves an entity known as Coal and Oil versus Ghcl. And this is a common issue, I think, that arises when users of international arbitration criticize the process, where decisions of the tribunal take longer than expected. So in this case, the decision took 19 months between the post-hearing submissions and the date of release of the award. And the court was invited to consider that this was somehow in conflict with the public policy of Singapore. And the court felt that public policy arguments tended to be the last refuge of the desperate. This, again, very, very strong words used by our courts. And the court also observed that in prior instances, where challenges were made to an award regrettably issued 10 years after the hearing, but no doubt upheld by the courts. So the court said, too bad. Ultimately, Jean, in Singapore, the evidential threshold in proving any violations of natural justice and public policy is going to be very, very high. So there are very, very, very few, very limited cases where the Singaporean courts have set aside or refused to enforce. Thank you, Jean.
Lip-san, thank you very much. It is indeed very, very interesting. It's just fascinating to see the difference in approach from different jurisdictions and different courts. I have some questions. I'm sure the participants on the panel have questions. But before we turn in the Q&A, we will give a word back to Charlene, who will introduce the next topic, the enforcement of interim awards. Of course, we all understand there is a spread. There is the interim awards, becoming more popular right now. The emergency arbitration is becoming more popular. So the issue arises, there is a potential for more and more of these issues arising out of the enforcement of such awards. So Charlene, without further ado, it's your turn, please.
Absolutely. Thanks, Jean. So as Jean mentioned, our next topic has really taken on increasing importance with the widespread use of international arbitration for all types of complex commercial disputes, which often do require interim arbitral relief as a means of preserving the arbitral process at the outset. Interim measures, as we will discuss them today, generally encompass an arbitrator's granting of temporary relief that is aimed at preserving the status quo pending resolution of the party's dispute on the merits. These measures are usually designed to prevent one party from taking action that might affect the enforceability of a final award or might otherwise render the arbitration meaningless. This usually concerns the destruction or disposition of assets or taking some other kind of action that could cause irreversible harm to one of the parties before their dispute can be resolved. Interim relief can be granted by the party's chosen tribunal or, as Jean mentioned, an emergency arbitrator who may be convened shortly after the commencement of an arbitration, but before the parties have had a chance to agree upon a tribunal that will decide the merits of their dispute. An emergency arbitrator would typically derive his or her authority from a set of arbitral rules that permit or offer emergency arbitration procedures. And we find these kinds of rules in the ICC rules or the SEAC rules, for example. And I think at this point, most arbitral rules, including the 2010 UNCITRAL rules, now recognize an arbitrator's authority to grant interim measures and provide that seeking judicial enforcement of such measures shall not constitute a waiver of the right to arbitrate. Nonetheless, enforcement is still up to national courts, and the approach taken will depend largely upon the legal regimes that are applicable in that country. Now, when it comes to enforcement of arbitral interim relief, there are generally two bodies of law that are going to govern. First, the New York Convention, and second, domestic law, which may be shaped by the UN model law on commercial arbitration if it has been adopted in that particular jurisdiction. Now, to start, the New York Convention does not expressly address the enforcement of arbitral interim measures. And on its face, it appears to apply only to awards, which begs the question and has for some time as to whether interim relief granted in the form of an order, for example, would fall under the convention's framework. The other issue that can sometimes arise under the convention, although the convention does not expressly contain any requirement that an award subject to enforcement must be final, it does in Article 5.1e permit non-recognition of an arbitral award that is not yet binding. And interim relief may arguably fall into that category. by its nature, because it's subject to revision or setting aside later by the merits tribunal, which will be based on later circumstances. So those are two issues that, that have been deemed to arise under the New York Convention. The model law, as revised in 2006, tries to fix those two issues. First, it provides that interim measures granted by an arbitrator are enforceable, regardless of what form the relief comes in, whether it's an award or an order. And second, it provides that interim measures should be deemed as binding as any other kind of award. But although the model law has been adopted in 85 states, including 3 of the 4 jurisdictions that are covered by our panelists today, it has not been as widely accepted as the New York Convention, and has not, for example, been adopted in Panama, where David practices. And David may be able to speak more today about how these issues are handled by the Panamanian courts. And even the model law is silent on other issues that may go to the enforceability of interim relief, such as whether relief granted by an emergency arbitrator through one of those procedures, for example, in the ICC or SEAC rules, who was appointed by the arbitral institution, whether that kind of relief would be enforceable in the same manner as if it had been granted by the party's chosen arbitrator or tribunal. And finally, the last practical issue that I wanted to mention was that the procedural mechanisms available for enforcement in the jurisdiction where enforcement is sought may also be important, as they can affect the timing of enforcement, which can be paramount when you're dealing with urgent preliminary relief. As I alluded to earlier, an application to enforce an interim measures award under the New York Convention may be subject to litigation over the other party's Article 5 defenses, which, at least in the United States, can take months to run its course. So when you have circumstances of real urgency, the effectiveness of the interim measure may actually hinge upon the availability of immediate temporary injunctive relief that mirrors the arbitral interim measure, or something like a judicial executor procedure by which the interim measure can immediately come into force with litigation over challenges to enforcement to follow. So without drawing out the windup any further, I will open it up to our panelists to discuss how some of these issues are treated in their respective jurisdictions, and for their thoughts on other strategic considerations surrounding the enforcement of interim measures.
Thank you, Charlene. Great introduction for the topic. It's a fascinating topic indeed. And we'll start with Yoka again. Are there any practical cases, any court cases in Japan that would give us a little view on how Japanese courts view or treat interim awards?
Sure, thank you, Jean. And not again, but actually, under the current legislation in Japan, interim award cannot be enforced. So there has been no court cases with regard to the enforcement of the interim award. But amendment of the Arbitration Act is currently being discussed by task force, under which enforcement of interim award becomes possible. So, and this amendment is basically purported to implement the 2006 Arbitral model law. So after this new Arbitration Act is amended, we hope that the interim award can be enforced in a similar manner under the Arbitral model law. But of course, some parts of the Arbitral model law needs to be modified to fit into Japanese legal systems and practice. So for the purpose of today's discussion, I'd like to assume that the current discussion, which is in the task force, which is summarized in a kind of tentative draft, is actually enacted, and would introduce several related topics in this regard. And the first topic is what kind of interim measure can be enforced in Japan, and the tentative draft provides that as one of the grounds to refuse the enforcement of interim award, that any interim award of the nature that cannot be enforced under Japanese law cannot be enforced. So it is kind of tautology, but this is understood to be to mean that this is basically the interim measures that are not available under Japanese law. So, for example, in Japan, like broad interim measures such as freezing orders or receivership orders or marital injunctions are not available. So I'm not sure whether arbitral tribunal often issue such interim measures, but even if such broad interim measures are issued by the tribunal, it is kind of unlikely to be able to be enforced in Japan. And the second point is, or second question is related to formalistic requirements, which is very strict in Japanese court procedure. So, for example, there is a kind of very specific way to draft the dispositive part of the judgment by the court. So, therefore, if the arbitral award, I mean the interim award, is slightly not fulfilling such formalistic requirements, whether such interim award can be revised and enforced. And the tentative draft that I call does not really refers to whether the court could do or could not do. But as you might be aware, a part of the model law, which is Article 17, allows the court to kind of revise the interim award to fit into the court practice or the court power to enforce it. But this part of model law is actually not included in a Japanese tentative draft. So it is likely that, in my opinion, it is likely that the Japanese court refused to modify the interim award, which is slightly not fulfilling the formalistic requirement and not be enforced. But it is, kind of left to the practice of the Japanese court, so it is not very known. And the third and the last point is very briefly, is how to enforce the interim award. And as again, as many of you might know, should know that how to enforce the interim award is left to the discretion of the each domestic court, and that is the same under Japanese law. And the issue is how to enforce some interim award which prohibit some action or order some action from the respondent. And interestingly, initially the draft of tentative draft included a clause to allow the court to pose a penalty for non-compliance of the interim award against the breaching party. But that clause was later excluded. So it is, again, very left with the domestic court, Japanese court, to how to enforce such interim award. And I'm pretty curious how such kind of interim measure is actually enforced in other jurisdictions. Thank you very much.
Thank you, Yoka. It's very interesting, especially the view that the Japanese courts are very formalistic and they will just follow the procedural aspects very strictly. It's quite interesting. I think counsel, when they deal with enforcement or when they deal with parties that relate to Japan, they should definitely take that into account and definitely seek advice from Yoka or her colleagues on the specific issues relating to enforcement of Japan before the issue arises. Thanks, Yoka, again.
Sure, anytime.
Thank you. David, the view from Panama.
Thank you very much, Jean and Yoko. I really like your presentation. Once again, Panama has a very good and reliable roadmap. And I say that not necessarily because the roadmap is always followed, but prior to the enactment of the arbitration law, interim measures were not enforceable by way of exequatur. So the exequatur in Panama, whether it be for arbitral awards or courts of law judgments, was reserved and limited to final judgments or final awards on the merits. That, however, changed in 2013 when the arbitration law was passed. So Article 43 of the arbitration law specifically allows for the enforcement of an interim measure within an arbitration, a foreign arbitration specifically. Unfortunately, the way it is set up, it is rather cumbersome because you have to go through the whole loop of the Supreme Court of Panama, as I mentioned earlier, and the exceptions or the objections to enforcement that are available as objections, for example, the public policy objection, the non-existence of an arbitration objection, plus other objections are available. And it's rather bureaucratic. You have to go to the Supreme Court. You cannot go directly to a trial court. The Supreme Court has to look at it. And then the Supreme Court has, if the Supreme Court grants it, there's a presumption for enforceability. But if the Supreme Court grants it, then it has to delegate upon a court. And by the time this is done, it is very unlikely that the measure, the interim measure, will serve its purpose. So it's really, as with everything in arbitration, it really depends upon the party's good faith. If a party sitting in Panama is ordered by a foreign arbitral tribunal to perform something based upon an interim arbitral award, then that party has the obligation to comply with it. Otherwise, it could face court action in Panama by way of this enforcement proceeding that is contemplated in the law. Now, curiously, and this is really a practice tip, there are alternative ways to get this done, because under the arbitration law of Panama, the ordinary courts of justice in Panama, the trial courts, retain jurisdiction to issue cautionary measures or provisional orders during the course of an arbitration or before the filing. So, for example, in a case which was pending in London, we were able to obtain a freeze order issued by a Panamanian court directly, even though the case was pending in London. And then the freeze order was ordered in Panama by a court of law, and the cautionary or the interim relief was remanded to the arbitral court in London, which in turn, when we wanted to undo the interim measure, the arbitrator in London said, I don't have jurisdiction to undo a cautionary measure issued by a court abroad. So it had to remand the case to Panama to get the order undone or to get the interim relief lifted. Curiously, and this is another thing, and I'm not going to reveal, but it's out there in the ICSID database. In another case that I worked with, there was an emergency interim relief order issued by an ICSID panel in a matter, and the way it worked is that the parties involved basically respected the order, and we didn't have to go through enforcement because. And you know, it's an ICSID case, so it will be very easy. And I strongly recommend that you take a look at it. It was worked by colleagues of ours out of Miami and Washington, and we were assisting them in Panama. So that precedent is there. I'm not going to reveal the name, but you will be able to find it if you just go into the ICSID database of cases. And it was respected, and it was an interim relief order. So I think that's a great precedent to show that Panama will respect and enforce. Unfortunately, there's no specific cases, because in that case, there was no need to go to court in Panama. But again, it's not a lost cause because of the bureaucracy. There's other ways of getting your interim relief granted, as we did. We also, by way of example, the Panamanian arbitration law defines norms or actions for preservation of evidence as part of interim relief. We were able to get a Panamanian court to preserve evidence prior to filing abroad, an arbitration abroad. So that we did directly by resorting to a Panamanian trial court. Again, this is cutting edge. This is something that will take time because of the existing precedent or the existing culture that interim relief was not enforceable by way of exequatur, and that has changed with the enactment of the arbitration law. Thank you very much. I yield the rest of my time, Gene.
David, I really appreciate the focus of your presentation
and my generosity for yielding time, Gene. Come on.
Absolutely, that was my second, and that was second after end. I really appreciate that. Going back to Ukraine now, Tatiana, any chance that interim awards can be enforced in Ukraine?
Thanks. It looks yes. First of all, we have the quite understandable, formal, but very clear provisions in the Ukrainian Civil Procedure Code, which provides for the later. And we have also the situations. We have 3 cases being brought into the courts for enforcement of emergency arbitrators award. Interesting that all these awards were issued under the Stockholm arbitration emergency arbitration rules, and in none of these decisions there was a notion that it's not enforceable. It is important. So it means that in principle the courts agreed that these sort of arbitral awards, interim emergency arbitrators awards, could be enforceable in Ukraine. But what we have an interesting situation, specific one. I just mentioned about this. If any questions, we can return back to other 2. It was the interim award issued in favor of the Russian web bank, connecting with the execution in the Ukraine of the prohibition to deal with the stocks of the company, Ukrainian company, being the daughter company of the Russian bank. And what actually happened at the time of the execution of this award, enforcement and execution, when the web bank applied, in Ukraine already existed the award, which was issued by the Ukrainian court on the basis of the application to enforce the decision of the PCA in the claim of Everest Estate against and others against the Russian Federation. Among the assets which were within the said arbitral award issued by PCA, it is an investment dispute, as well were the said Ukrainian Prominvest Bank, whose actions were now under the specific decision of the Ukrainian court with the prohibition of fulfilling a lot of different actions. And at the same time, it was stated that this bank is one of the assets against which the execution could be sought. It means that at that period of time in Ukraine already existed the judicial decision which entered into legal force, which provides for the certain actions and allows the Ukrainian authorities to sell the assets of this bank in order to cover the demands issued by the court and confirmed by the decision of PCA. Using these circumstances, the Ukrainian court said that it is a part of public policy that if there is the existing and entered into the legal force, the decision of the court, it should be enforced. and executed as a final decision, and that in this case, the allowing of the execution of the emergency arbitrator's award just means the violation of this finality and the judicial force of the already existing Ukrainian award. That was the reason why the actually the state court refused the execution, saying that it's not possible, according to Ukrainian public order, to execute against the already existed Ukrainian decision, which is already in this process of execution as a final one. I am not confident whether I need to stop because we're in time. I can limit it now and return back to the other two issues later in order to allow my colleague to provide for the presentation, if it's acceptable, Jean. We can do in such way.
Yes, absolutely. Yes. Appreciate that, Yana. Thanks for your comment. And Lipsan, please.
Thank you, Jean. I'll try my best to keep this moving quickly. So in terms of interim relief, I think, speaking for myself, the approach that I took was the trend towards having emergency arbitrators appointed. So just a quick recap for some of you. Essentially, arbitral institutions have promoted emergency arbitration in their bid to provide users of arbitration with a more efficient recourse, especially when the tribunal has not yet been constituted. This has proven to be useful in certain cases where injunctions are required, where some intellectual property has to be obtained. But not everyone would like to sit as an emergency arbitrator because there's a lot of pressure. If you look at the SIAC's panel, you will see that the arbitrators named there, only those with an asterisk have volunteered to take on the burden of being an emergency arbitrator because there's a lot to turn around in a very short space of time. Now, in Singapore, this mechanism started way back in July of 2010. But what is interesting is that only in 2012 did the government change our International Arbitration Act to make it clear that an emergency arbitrator would be similar to any other tribunal. And therefore, the emergency arbitrator's decision becomes enforceable like any other arbitral decision. Now, this is a very, very important development back in 2012. And those of you who need the citation need only go and look at Section 2 of the Act. Now, back to the Singapore context and the rules, an emergency arbitrator under the Singapore rules will enjoy the same powers as a normal arbitral tribunal, including the ability to determine his jurisdiction, to award interim relief, and of course, apportion costs. Now, the emergency arbitrator is very unlikely to form part of the main tribunal. There are prohibitions, and the award of the emergency arbitrator would cease to have effect within a certain number of days. Now, all those are in the rules of the SIAC, which are very well ventilated. Now, the last point I'm going to deal with in a minute is just to highlight that although we have amended our laws to make it clear that an emergency arbitrator has the same status as a normal tribunal, it remains to be seen whether a foreign emergency arbitrator's decision or interim decision would be enforceable in Singapore. So we just contrast the express provisions that the Hong Kong Parliament has made to its laws to make it clear foreign seated emergency arbitrations will be enforced. Back to you, Jean.
Thank you, Lipsan. Appreciate that. It was a very brief and very to the point presentation. Now we have a very brief Q&A session. It's about 5 and 7 minutes before we all get switched to the breakout rooms where we can continue our discussion separately. The question that arises is, whether domestic and international public policy may also be a basis for the court's consideration to enforce an award that may have been vacated at the court of the seat of arbitration. So what happens if the award is vacated? Of course, there's a article that under the New York Convention, the court may refuse the enforcement, but would the public policy be a basis for a court to refuse the enforcement of such award? And Charlene, would you be able to give us maybe just your view from New York on that issue?
Yes, absolutely. I mean, I think it's a very interesting question. A lot of these grounds for non-recognition under the New York Convention have significant overlap, and an objection that falls under one rubric can very easily be reframed as an objection under a different rubric. I think when it comes to annulled awards, there are probably various objections under Article 5 that would be implicated by the enforcement of such an award. There is, specifically one ground that deals with, I think it's Article 5.1e, that deals with awards that have been set aside and gives discretion to the recognizing court to decline enforcement where the award has been set aside by the courts of the arbitral seat. But I do think that public policy may be implicated as well, and not always in the most expected ways. The one sort of interesting case that I'll mention from New York is the Comisa case against Pemex. This was one of the very, very few cases that exist in US jurisprudence where a US court did actually recognize and enforce an arbitral award that had been set aside by the courts of the seat. In this case, it was the courts of Mexico in an ICC arbitration between a Mexican subsidiary of a US company and Pemex, the oil and gas arm of the Mexican state. And in this case, the facts were very, very specific and rather egregious. I think in this case, there was an arbitration clause in a contract between Comisa and Pemex, which was entered into willingly by Pemex. And only later was a law passed by the Mexican legislature, which essentially invalidated that arbitration agreement. But only after Comisa had relied upon the arbitration agreement, initiated arbitration, and gone through an entire arbitration, received an award. So on the basis of this new law, which was applied retroactively by the Mexican courts, the award was annulled in Mexico. And this all came to the attention of the US court, before whom an enforcement petition was pending. And the US court looked at US public policy for purposes of determining whether it should defer to the foreign annulment decision. So it's sort of a reversal of the normal role that public policy would play in these cases. And the US court said that the foreign annulment decision in this case was the decision that violated, under US public policy, the most basic notions of morality and justice and fairness, and decided to actually confirm the award on that basis.
Yeah, thanks, Charlene. That's very interesting indeed. Yes, it was an interesting case. Lip-San, could you perhaps also comment from a Singapore side on that issue?
Yes, I can. The Singapore position has also examined Article 5.1e, as Charlene rightly points out, in terms of the difficulties if there is another pending setting aside in another jurisdiction before another national court. We have some jurisprudence in Singapore which has expressed sentiment that the courts would have serious doubt, in those words, serious doubt, whether it could retain any discretion, whether or not to enforce an award, if that award had already been set aside at the seat of the arbitration. Now, in another case, what was interesting was that whilst the setting aside was pending in the Danish courts, the courts took the view that it nonetheless could refuse the adjournment because the merits of the setting aside had not yet been fully ventilated before the Danish courts. So I would suggest the distinction being whether another national court had fully and finally set aside an arbitration before it was attempted to be enforced in Singapore.
Understand.
I hope that can contribute to the discussion.
Well,
Thank you.
Appreciate the contribution, certainly. At this point, we can continue the Q&A separately. I know there are some more questions that were raised, and please hold on to those questions. All the participants now will be switched to the breakout rooms with one of the speakers or panelists, and you will have an opportunity to discuss these questions with them directly. Thank you very much, and thank you very much to the moderator, to Charlene, to the speaker, to the panelists, and it was a great discussion. Appreciate that.
Thank you, Gene.
Thank you so much, Gene, and thank you. I'm telling referring to your names as they appear in my screen. David and Lipsan and Charlene and Tatiana and Yoko. Thank you so much for educating us on enforcement and sometimes how to deal with cases and awards that need to be complied with, sometimes through the usual routes and sometimes through more knowledgeable actions as David shared it when dealing with cases that involve Panama. This was a great discussion and a lot of food for thought concerning investment arbitration, commercial arbitration, and enforcement of arbitral awards. And with that, we will send everyone to breakout rooms. Enjoy this time. There's no agenda. The breakout rooms are provided for people to meet each other if you want to, and for attendees to meet our stars, and of course our stars are you guys. So give us a second and we'll be right with you in the breakout rooms.